Hi there, how are you doing? In this video, we are basically going to be looking at standing in judicial review, or also known as locus standi. And basically, we're going to be looking at individuals, entities, or bodies that can be subjected, or those that can be said to be having standai, or also known as locus standi. Of course, those include individuals. They also include organizations, and also include the local government or police. Hello once again, my name is Mutiawa Conrad. I am a lawyer and a private law tutor. And before we start on our topic, I encourage you to like, to subscribe to my channel, and also ensure that you share and also turn on the notifications so that you do not miss a single video whenever and if it is released. So ladies and gentlemen, let us start right away. And again, I encourage you, gentlemen and ladies, to ensure that you contact us in case you feel like you really need that individual touch and you need to be tutored, you need to be mentored. You can always contact us directly. Our numbers are down in the description box, and we can always make an arrangement of a one-on-one tutorial program where we can come to your office, to your home, or anywhere that is convenient for the both of us. So let's start right away by looking at standai, or what is also known as standing in judicial review. And basically, when we talk about standing, what you have to note here is that you cannot apply for judicial review unless you have locus standi, or as it's also known as standing. This is very important because for you to proceed and apply for judicial review, there must be a connection between the applicant, i.e. the party applying for judicial review, and the action. So there must be that connection. And it is really of essence. It's really very important because the reason why court will always look as to whether there is locus standi, or also known as standing in judicial review, is because court is trying to avoid what in law we call mere busybodies. Mere busybodies are simply these parties who are simply wasting court's time, and they do not have the necessary locus standi to appear before court. So for you to proceed and apply for judicial review, in law we say that there must be the necessary locus standi, the connection between the applicant and the action. Okay, this is really very, very important. So we are basically going to look at which entities, which persons, which individuals basically have locus standi, or also known as standing. So the first category of individuals, or the first category of entities that has a locus standi, is known as individuals. Okay, so that's category one. So individuals in law have locus standi. They have standing in judicial review to actually apply to the court so that their matter is given ground or given audience to be had under judicial review. So individuals have locus standi. Authority for that position, I encourage you to go and look at the case of R versus Ware Valley District Council ex parte Binks. It's a case of 1985, volume 2, All England Law Reports, page 699. The brief facts of this case were that a street vendor successfully sought judicial review of the Ware Valley Dam District Council's decision. Of course, this was made without prior notification or accompanying reasons to give her notice to quit her hot food takeaway caravan. So she applied for judicial review as an individual, and of course she was successful. Also of interest, I encourage you to go and look at the case on the same principle. Look at the case of Alfred Njau and others versus City Council of Nairobi. This is a case of 1982 to 88. Kenya Law Reports, page 229. And basically in this case, resolutions relocating 115 houses to other persons was challenged by the applicants who were occupants, and a preliminary point of objection was raised as to locus standi, and of course court went on to hold that the applicants had standi. Why? Because definitely they applied as individuals, and here court resolved by saying that, look, individuals also have locus standi to apply for judicial review. So those are very two interesting cases. You can go and look at them in detail. Also of interest, I encourage you to look at the case in Uganda, Inland Ports Limited versus Attorney General and Great Lakes Limited. This is application number 145 of 2007. Basically, in this case, the court noted that sufficient interest means that the matter must directly affect the applicant in some way, however small. So this case basically is trying to explain what amounts to having sufficient interest in a matter, what amounts to standing in judicial review, what amounts to locus standi. That's what basically the judge was trying to say, where court held that basically having that direct affection or attachment to a matter, basically it doesn't matter however small, but provided there is that connection or sufficient interest, then it is good enough no matter how small it is. So basically that's what we mean when we say locus standi. Let's now proceed to look at a second category of individuals that also have locus standi, and that is basically individuals with a genuine public or constitutional interest. So any individual, okay, provided they have really a genuine constitutional interest in any matter, or they have a genuine public interest, okay, then such persons in law have the necessary locus standi, or standing as we called it. So this is really very important to note, and authority for that position can be found in the case of R versus Secretary of State for Foreign and Commonwealth Affairs, ex parte Rees-Mogg. This is a case of 1994 Queen's Bench, page 552. And basically in this case, Lord Rees-Mogg, who was a peer in the House of Lords, unsuccessfully sought judicial review of the Foreign Secretary's decision to ratify the Maastricht Treaty, although on the facts his claim actually failed. Okay, so based on the facts he was not successful, but of interest here to note is that Lloyd LJ noted in that case of interest, of course, to our discussion now, that there was no dispute at all as to standing, and that court accepted, and he quoted open quotations, that we accept without question that Lord Rees-Mogg brings the proceedings because of his sincere concern for constitutional issues. So court goes on to state that whereas Lord Rees-Mogg was unsuccessful in his claim or his application for judicial review, but that it wasn't under any doubt that as a private individual who had a genuine public interest in constitutional issues of that country, he had locus standi to apply for judicial review. So this case really cements the position that any individual with a public interest or with a constitutional interest or matter can always apply for judicial review, and under law we say that they have the necessary locus standi. Let's now proceed to look at the other second aspect, which is really public interest. Okay, so again, any person with any public interest, okay, in a matter or in a decision has locus standi to proceed and actually apply for judicial review. Again, authority for that position can be found in the case of R, that is Fickens versus Secretary of State for the Environment, Food and Rural Affairs. This is a case of 2003 EWCA Civil, page 1546. Go and research that case and find out the facts. Now, let's now proceed to look at the second category of entities or persons or bodies that actually have standing or locus standi, and that is groups or organizations. So even groups and organizations actually have locus standi to apply for judicial review, and basically under this category we're going to be looking at one, acting in public interest. So any organization or group that is acting in public interest has locus standi, and it can successfully apply for judicial review. And of course, here of interest, I would encourage you to go and look at the case of R versus Secretary of State for Foreign and Commonwealth Affairs, ex parte World Development Movement Limited. It's a case of 1995, volume 1, WLR, page 386. And basically in this case, the brief facts are that the pressure group, which was known as World Development Movement, successfully challenged the Foreign Secretary's decision to grant funding for the construction of a Malaysian hydroelectric power station which was on the Persian River under the Overseas Development and Cooperation Act of 1980 of that country, on the basis of it being economically unsound. So again, we are seeing a pressure group, applying for judicial review, just a mere pressure group, and court. It was never in dispute, and court observing that indeed they had locus standi even when they were just a pressure group, but they were doing it really for purposes of public interest, and as such court found that they had the necessary locus standi. Why? Because they were acting in public interest. This was a national project which did not make any economic soundness, so to say. So let's now proceed to look at the second category, or the second element under this second category. That is groups or organizations acting on behalf of the interests of its members. So if there is an organization and it's acting on behalf of the interests of its members or of its persons that are under that organization, then the same again has locus standi, or standing as we refer to it. And authority for that position again can be found in the case of R, that is Montpelliers and Travers Association and another versus Westminster City Council. It's a case of 2005 EWHC 16. So that case, basically an association representing the residents of 2 squares in London successfully this time challenged the traffic order made by Westminster City Council, which affected their residential areas. So again, we are seeing an organization, acting on behalf of the interests of its members, going on to challenge a decision by way of judicial review, and court finding that actually they have the necessary locus standi to proceed. Very, very interesting. Let's now proceed to look at the last category of entities that actually have locus standi, and that is local government or stroke police. That is the third category. So local government or even police actually have locus standi to apply for judicial review. This is very, very important to note. So it is very interesting, but a local government actually can apply for judicial review of the decision of, let's say, central government. Okay, very interesting there. And we're going to be looking at a number of interesting cases. And first, let's start by looking at the police. Okay, so the police can actually apply for judicial review of a decision passed by any other entity of government. Very, very interesting. Authority for this position can be found in the case of R, that is Chief Constable of Great Manchester Police versus Salford Magistrates Court and Hookway. This is a case of 2011 EWHC page 1578. And basically in this case, the Chief Constable of Great Manchester Police applied for judicial review of a decision of the Magistrates Court, albeit unsuccessfully on the facts. Here meaning that although the Chief Constable of Manchester Police was actually unsuccessful on the facts, but it was never under dispute, and court actually accepted that he had locus standi to apply for judicial review even as a police officer or as a constable. It was never under any doubt that actually he had that locus standi. Let's now proceed to look at the second local government or government department, and that is actually the local government itself. So the local government can actually apply for judicial review of a decision of any other entity, and of course authority for that position can be well found in the case of Nottinghamshire County Council versus Secretary of State for the Environment, and that's a case of 1986 volume 1 SC page 240. And basically the brief facts of this case were that Nottinghamshire County Council unsuccessfully sought judicial review of the Secretary of State guidance determining expenditure targets for local authorities, which they contended that were unfairly low. So in their argument, they were saying that this was unfairly low. The House of Lords held that the councils would not intervene on a matter of unreasonableness in the absence of, for example, bad faith or improper motive in respect of public financial administration, which had been approved by the House of Commons. So again, we are seeing that actually even local councils can apply, though the facts of this case, the local council was unsuccessful on the facts, but court accepted that indeed the local government can apply for judicial review of the decisions of any other entity or body. So basically, ladies and gentlemen, that was it for today's class. Once again, I encourage you to like and to like my channel, to also ensure that you subscribe and also turn on the notification. And once again, those students interested in private tutorial services, you can always contact us and we can make out an arrangement to tutor you privately, you know, where you need a little brush. And we keep on really emphasizing that these tutorial sessions really work. They really cause a fundamental change in your grades. They help you to appreciate and understand these legal concepts a little bit more, especially when you engage us more on a private level. There's so much for us to always cover, which we cannot exhaustively cover in these videos due to time, and also trying to narrow down concepts for your easier consumption or taking in or understanding a little bit in an easier manner. So please contact us. Our numbers are down in the description box. We can always make that private arrangement, especially in your holidays or at any time where you feel you need our help. We are always at your service. Thank you very much. We meet again in another class. Bye-bye. See you.